This is Block 8, Pax Americana, Section 6, The Seeds of the Civil Rights Movement, with the section beginning with Sweatt v. Painter, which is not this. Yoink, yoink. In 1950, the Supreme Court ruled that a separate law school that had been set up for black citizens in Texas was unconstitutional. Jim Crow had set up a system where everything had a white, there was a white counterpart and a black counterpart. And the same thing went for law schools in Texas. There was a law school where white students went, and there was a law school where black students went. And this state of affairs was threatened with a lawsuit. It went all the way up to the Supreme Court. That the argument that the state of Texas was making to defend its segregation was that the Plessy v. Ferguson case of 1896 had said that separate facilities were constitutional as long as they were equal. Now, the defendants in this case said that offering a black law school did not provide equal opportunity because law firms did not hire equally from the two law schools. The quality of the professors was different at the law schools. The facilities were different at the law schools. And because of all of those things, these things were not equal. And because they were not equal, they were unconstitutional. Although this is a victory for civil rights, and a fact that's going to be used in the Brown v. Board of Ed case 4 years later, the court declined to say that separateness was inherently unequal. The court did not say that separate equals unequal. The court did not say that having separate schools was by definition unequal. All they said in this particular case was that these schools were not equal, and therefore it was not constitutional. The implication being that if the state of Texas had set up a completely equal segregated law school, it would have been constitutional. We are working our way towards a judicial sense of forced equality, but we're not quite there yet. Sweatt v. Painter was a case that was important in the sense that it showed that although many southern states argued that their facilities were equal and therefore they could be separate, in reality, most of these separate institutions were not, by any stretch of the imagination, equal.